One of the events we're looking forward to is the chairman of the Law Reform Commission to tell us about the recommendations that have been made. I understand that the report has just been released. I don't know what the recommendations are. We'll all find out for the first time this afternoon at the toward the end of the day. To start us off, though, and to wake us up and get the neurons clicking away, we're very pleased to have a popular speaker who we all know from these events, and who will talk to us in his usual stimulating way, I'm sure, about unequal division of property. So I'm pleased to present Professor James G. McLeod.
Let me preface my comments by pointing out that when I saw the program topics available for selection for this conference, I thought there were a whole bunch of really interesting topics. Unfortunately, this wasn't one of them. Like most, I was willing to accept that the odds on getting an unequal division of matrimonial property in front of the courts were about square root of 0, and assuming that you could convince someone to give it to you, the costs of processing an unequal division claim were so high that unless you had the type of case that the carriage trade seems to own, you couldn't afford to litigate the case. However, not wanting to believe that at this point in my career I could only be trusted with areas that were either intellectually uninteresting or practically irrelevant, I immediately rationalized this whole area in the topic I'd been given, to the point that if anybody could create an issue where there wasn't one, I could do it. And secondly, having done my best to clarify the law of support and assist the judges in their endeavor, it was time to turn on to new challenges, hence unequal division of matrimonial property. I'm delighted to have that topic. First step, it strikes me, in trying to deal with unequal division of matrimonial property is to try and decide whether the perception that claiming unequal division of property is largely a barren issue to pursue accords with the reality. Starting point, I think, is Justice Galligan's decision in Skrilj, S-K-R-L-J, case I can only remember as the only one with no vowel anywhere reported that I'm aware of. In the case, Justice Galligan takes the hard, if not the high ground, and says, there's no general power to redistribute assets, there's no general power to distribute wealth, there's no power to award palm tree justice. There's no power to do what's fit and just. Unconscionable is what you got to overcome to change the equalization, and unconscionable is lots higher than inequitable was. Don't ask us to redistribute the property. That's the stuff of settlements, and when you come in front of a judge, all you got a right to accept is the judge will apply the strict words of the act, conduct the equalization accounting, and let the chips fall where they may. As an aside, having said that, note that in Skrilj, Justice Galligan appears to have directed an unequal division of the property and appears to have relied on post-separation V-date factors in order to effect his unequal division. However, it did present from the comments a minor stumbling block to those hoping to get in there and do some palm tree justice. However, there was hope. He'd made the same sentiments earlier on under the Family Law Reform Act, and we had managed to reverse him on that occasion. So, applying the lawyer's credo, if at first you don't succeed, relitigate the issue and hope for a different result. 'Twas not to be. Justice Galligan got a hold of another one in Humphreys and Humphreys. That was the one, if you remember, where there was basically a jointly held home and a jointly held cottage. Linda Silver Dranoff tried to play a nice game saying put the cottage on one side, the house on the other side, and equalize on that basis. Justice Galligan said, nice try, no luck. Didn't you listen to me in Skrilj? Read my lips. You're not going to do it. And he then quoted from Skrilj. In case we hadn't read Skrilj, he quoted right back at us, no power to equitably distribute property, no power to reapportion assets, unconscionables bigger than inequitable, and even if you can get over the unconscionable threshold, all you can do is reapportion the difference between the spousal NFPs, and if there is no difference, you can't do anything. At this point, things looked bleak for those looking for an unequal distribution of property. However, if you can't run up the middle, what you seem to have to do is drop back 3 steps, pass, go over the top, and appeal them. So, enter Burdett and Burdett. Burdett, at trial, you remember Justice Granger reinforcing Justice Galligan's views from Scrilge and Humphreys in no uncertain terms. Justice Granger saying, there's no palm tree justice, there's no power to redistribute assets, unconscionable is much higher than inequitable ever was. However, and he throws in a little fruit for thought, he says, there's no automatic right to equalization, you earn the right to equalization, and he hooked in the section 5.7 considerations. He says, you do what's in 5.7, and you get the right to equalization. The corollary, obviously, is if you don't do what's in 5.7, then maybe equalization is inequitable. He then continued, however, in order to bump inequitable up to unconscionable, what you need is some hint of mala fides in the abdication of responsibilities. Ms. David, not wishing to be stuck with the result at trial, appealed. Unfortunately, Justice Galligan anticipated this move, got himself appointed to the Court of Appeal, and decided Burdett and Burdett. Now, let me stop at this point and say Burdett and Burdett is one of my favorite cases. If you've got a matrimonial property case, all you really need is Burdett and Burdett. It's a superb decision. Justice Galligan does what he did what he does perhaps better than anybody else. He sets out a framework to follow. It's neat, it's clean. He tells you how to approach a property case. He says, fix the valuation date. Figure out what interests in property the husband had on those dates and put them onto his side of the accounting. Value it as of the V date. Subtract out the deductions under 4.1AB, subtract out the exclusions under 4.2, and magically you have the husband's NFP. Do the same to the wife. Then subtract the lesser NFP from the greater NFP and you get the difference. And then you divide that difference equally unless you can prove unconscionability under 5.6, and then you can reapportion the difference in the spousal NFPs. Note, I don't think Burdett says that once you get over the unconscionable, you can just get in there and muck around and throw stuff all over the place. All you're going to get to do is redistribute the difference between the spousal NFPs. And he said, in this case, there really is no difference in spousal NFPs, therefore it can't do much of anything. He reinforces the unconscionable threshold. It's a high threshold. He reinforces the no palm tree justice. All in all, he hammers down quite tightly what he did in Scrilge and in Humphreys. Note, if you will, a point missed by many. Burdett and Burdett was a case where an unequal division of property was ordered. If you look at trial, Justice Granger goes through the accounting and says almost everything is jointly owned, it lines up, but there's some movables owned entirely by the wife. My conscience is shocked by an equalization of everything in this case, and he gave all the value of the movables to the wife. So in fact, there was an unequal distribution ordered. The end of Burdett and Burdett, I think that the circle comes right back to where we started, and essentially what you found is the odds on getting an unequal distribution is pretty remote, and the cost of doing it doesn't justify it in most cases. The problems, I think, arise from 3 points. 1, the high threshold attached to the word unconscionable. 2, the inflexible valuation date that the statute imposes on us. And 3, the reluctance of Justice Potts in Kelly and Kelly to allow Justice Granger, in his guise as B. Thomas Granger QC, to argue unconscionability based on post-V-date factors, and then the follow-up refusal by B. Thomas Granger QC, in his guise as Granger J, to refuse to allow anybody else to argue unequal division based on post-separation factors. At this point, most counsel found themselves in the somewhat difficult task of explaining to their clients, okay, it may well be that the effect of equalization of net family properties is inequitable and unfair, but that's okay in law because it's not unconscionable according to the legal factors. Clients didn't take it well. I had 4 at the time. They took it very, very badly. Out of a sense of self-preservation, most lawyers decided that let's try one more time. If we can't get there directly, let's try an end run on this thing. And they addressed those three factors I pointed out to you. One, we tried to attack the threshold. We got the odd little victory here and there, but the courts have held firm on this. Unconscionable is greater than inequitable. You need the conscience of the court shocked, and that's not easy to do, apparently. You need some hint of mala fides, I think. All in all, not a fruitful route to pursue. Second, we turn on the valuation date. Not a lot of room here. The statute fixes it. Now, take a look at two cases. If you've got highly volatile property values, the cases are Golini and Toro Santucci are two nice cases. And what they deal with is the precise words of the valuation date. And it says, the earliest date at which the parties are separate and apart with no reasonable prospect of a resumption of cohabitation. Well, the literature says when marriage breaks down, we have hopes. Maybe we can put it all together. Maybe the last 15 years of my life have not been a total washout. Maybe, just maybe, we can make it work. Do you have a prospect of reconciliation for some short period after physical separation? Take a look at Golini, Toro Santucci. Maybe you got a little room there with highly volatile assets. The third one was, maybe we can convince the judges they should take into account post-V-date factors. If we can't deal with the threshold, maybe we can bring more stuff into the hopper. A few cases actually succeeded on this one. Scrilge, as I said, considered post-separation factors. There's some throwaway dicta in our Court of Appeals decision in Rawley, where they said, we assume post-separation decline can be dealt with under 5-6. You then got Merklinger, which is another cute case to play with, where Justice Jennings found that his conscience was shocked by the husband's post-V-date conduct, and he said, I disagree with Justice Granger. He's wrong. And I say you can take into account post-V-date factors. That's been followed up by Roback, and Roback, R-O-B-A-C-K, I think is the spelling, July decision at the General Division. Both of them Stephen Grant cases, so obviously he's still trying. He's not giving up on post-V-date factors. However, I think by this point, most of us had quit. Why bang your head against the wall? Going directly at 5-6 doesn't usually work. So if you can't run up the middle and you can't pass over the top, just ignore the whole thing, do an end run, and hope that you can get away with it some other way. Never do directly what you can do indirectly becomes the maxim of the unequal division cases. Two routes you might consider. One, if you don't like the result of the equalization of NFPs, then let's rearrange the ownership piles so that we come up with different NFPs, different equalization numbers, and let the other side worry about 5-6. And the second one, I really like, one way or another, you knew I would get this in, go back to the future and play your support card. If you can't get there based on property, claim support and accomplish the same thing through the back door. Turning to the first one, reapportioning the ownership piles. Well, Justice Galligan has told us repeatedly, you can't just get in there and mess around with the piles. You gotta pay attention to ownership principles. Couple points to make clear. One, two Court of Appeal decisions you should note. Golick is one and Hoare, H-O-A-R, is the other, both of them in the notes. And they both say if you got a jointly held piece of property, you can't just line it up on one side and say that person's the owner because you like the result you get. You got to put a half interest on each side of the thing based on ownership principles. So that's gone. If you're going to redo these ownership piles, you're down to trust law. Resulting trust. I loved resulting trust as a student. Unfortunately, somewhere along the line, we all forget what resulting trust is about. We all argue it. I like to allege a resulting trust. Why? Well, I don't know, maybe there's a common intention, and the judges tend to give it the respect that type of an argument is due, and resulting trust doesn't seem to go very far. That then takes us on to constructive trust. I don't think anybody knows what the state of the constructive trust law is at this point. Tim's going to talk about it in a while. If anybody knows, Tim knows. That's my way of passing the buck. However, I do think the Supreme Court of Canada has distinguished itself in this area now that I know they're both gone. And in 1975, nobody's fool this child. In 1975, the Supreme Court of Canada explained the law of constructive trust. They made it very clear, and they said it's got no real place as a viable force in family law. It's an institutional constructive trust. It doesn't apply in many cases, and there is no such thing as a remedial trust. They said that. 5 years later, Supreme Court of Canada reappraised its position, said, gee, y'all misunderstood us. When we said there wasn't a remedial constructive trust, what we meant is there is a remedial constructive trust, and that's what they decided in Petkus and Becker. However, they didn't tell us whether it applied under matrimonial property legislation. That point was awfully unclear, and the uncertainty ties into the Supreme Court of Canada's decision in Leatherdale and Leatherdale, which is under the Family Law Reform Act. Justice McIntyre, in a minority decision, said, for the reasons given by Justice Laskin, I find constructive trust doesn't apply under the FLRA. Justice Laskin said, I expressly decline to decide whether a constructive trust applies under FLRA. We sort of played around with it. People didn't want to use it. It sounded sort of funny. And then all of a sudden, out of Toronto came Rollick and Rollick, where Justice Walsh said, sure it does. Court of Appeals said, okay. And up it went to the Supreme Court of Canada. Over a very strong dissent by Justice McLachlin, majority of the Supreme Court of Canada, led by Justice Corey, held that the remedial constructive trust applied under the Family Law Act. Note, when we get to Peter and Beblow in March of 1993, we've got another role reversal, and I suggest another revisionist view of law. This time, Justice McLachlin writes the majority reasons, Justice Corey writes the minority reasons, and you can read into it what you will. However, by the time we sort all of this out, and now we're all yelling constructive trust. You gotta plead it. We issue our statements of claim or notices of application. We yell, we want a constructive trust. The reason, obviously, being post-separation changes in value. Just as we all get used to doing this, and we almost have our judges trained to come along with us for the ride, the real estate market turns over. All the properties dive down. All of those people who yelled remedial constructive trust say, excuse me, I'd like it back now. I don't want my constructive trust. Y'all feel free, unjustly enrich yourself. By all means, do it. And all the owners turned around and they started to yell, reverse constructive trust. Damn, I'm going to be unjustly enriched if you don't give my partner half of this stuff. This point, total disarray in the case law. All the wheels have fallen off the wagon. Nobody knows what's going on. But now we have a way to deal with unequal division because we have chaos and uncertainty, and that's what litigation and academia is all made up about. So we got at this point at least a window of opportunity. Second way I suggested that maybe you could try and avoid all of this thing was to try to evoke support laws. And I've decided that whoever thought this one up watched too much Star Trek. And Star Trek I've always thought is a tremendous teaching tool. Those of you who don't watch it should. If you think back to the old Star Trek, the real Star Trek, Captain Kirk, the old Kobe Maru defense, that they had this test and nobody could pass it. Everybody got blown up in the simulator, all but the big fella. And Captain Kirk solved it. We don't find out till Star Trek 3 how he did this, and we find out he cheated. He didn't like the rules of the game, so he said, I won't play. Well, that's what you do in the support case. You say, I can't do anything with these stupid property rules, therefore, I'd like lump sum support. Now, I want my lump sum support. Y'all give me that lump sum support, and at the end of the day, what the lump sum support does is forces you to redistribute the capital under the guise of a support order and let me deal with it. And in fact, it worked on occasion. That's what Daroon and Daroon did. Court of Appeal decision from the late 70s. They didn't like the fact they couldn't do much on the property division, so they awarded a lump sum support order. Justice Walsh did it in a case called Hume, which is set out in the material. Wife had to make an equalization payment. He didn't like that, so he broke it up into installments, awarded lump sum support, set it off against that, and ordered costs against the husband. All in all, an effective way to come around the end and get there. Well, Court of Appeal leaps into the fray, a case called Manarino and Manarino, and said, no, we don't think so. We don't think so, that you're not supposed to get out there and redistribute property under the guise of support. So at this point, my talk was done. I thought, this is not bad. I can now spend a couple minutes reviewing the state of trust law, looking at the success of bringing in post-V-date factors, and thirdly, looking at the likelihood of lump sum support, concentrating on Moog and Moog, and Justice Steinberg's decision in Elliott. Then I'd sit down to thunderous applause, or at least not have anything thrown at me. However, just when I thought I had it all figured out, our appeal courts came through the center of this whole thing and just muddied the waters up beautifully for us and threw a little confusion around. 2 Court of Appeal cases you should be aware of that are recent, and out of deference to yesterday's company, one Supreme Court of Canada decision, all of which affect unequal distribution. Court of Appeal decision you got to look at is ARNT, if you haven't already seen it, A-R-N-D-T. It's a decision of the Court of Appeal from the 12th of October, 1993. Supreme Court of Canada decision I think you want to look at that affects property and the redistribution of ownership interests, Peter and Beblow. And the Court of Appeal support case I think you got to look at is Elliott and Elliott, 8 October 1993. It'll be reproduced in RFL extremely soon without an annotation, I might add. And I'd like to throw in some honorable mention for the Manitoba Court of Appeal of Mehta, M-E-H-T-A, and Mehta, M-E-H-T-A, which is reported in RFL 3rd. These 4 cases give you, I think, some real room to start to play with those 3 points I raised. 1, redistributing ownership interests. 2, post-V-date factors. And 3, what do you do with lump sum support? On the first one, changing the ownership interests, as I mentioned to you, Golick and Hoare had both said, you put a half a joint interest on each side of the accounting sheet and go from there. The trial judge in ARNT had put the entire joint interest on the wife's side of the ledger sheet and done his equalization accounting. On appeal, Justice Weiler said, you can't do that. It's a joint interest, half goes on each side, and it doesn't matter that you may not be a pleasant person, you can't do that. However, if you look at the majority judgment, the majority says, sure you can. Trial judge didn't err in leaving the entire property, albeit in joint names, on one side of the ledger. Why? They don't tell us, but they did it. So now, maybe you can do it and maybe you can't, but I don't know why, and they didn't tell us. What about Golick and Hoare? Not mentioned in the short reasons of the Court of Appeal in ARNT versus ARNT. While I'm dealing with joint property, one of my pet peeves has always been the pretrial sale of jointly held property, that assuming you figure out how to get one and then you want to appeal it, nobody can figure out where you appeal to. If you look at Martin in a bunch of cases, Court of Appeal couldn't decide whether it was an interlocutory order or a final order. You might put a little asterisk. Case called Harewood, H-A-R-E-W-O-O-D, at 45 RFL 3rd. Short endorsement. Court of Appeal said a pretrial sale order is a final order. I just throw that one in for free. However, so the Court of Appeal in ARNT says that sometimes you can put all of a joint interest on one side. They then say the whole problem in this area comes up because of the change in values post-separation and because of the role of constructive trust in this mess. Justice Weiler sets out the issue very, very nicely. Justice Weiler then says, I don't have to decide whether post-V-date factors count, so I'm not going to consider it. No real help there. Then she says, as to the remedial reverse constructive trust, which is what was alleged in the case, she says, I'm not going to tell you whether you can use a reverse constructive trust or not, but I will tell you, even if you can use it, you can't use it if you don't make full disclosure of all of your financial circumstances, and you can't use it if you're the cause for the change in value. The majority says on reverse constructive trust, nothing. Majority says on post-V-date factors, look at the last paragraph of the short 2 pages the majority writes. The majority says, in the last paragraph of their judgment, the trial judge considered hardship but couldn't find unconscionability within the meaning of the section, gave the appellant relief, etc., find no error in the exercise of his discretion. If they weren't going to consider post-V-date factors, then there was nothing for the trial judge to subject to an exercise of discretion. The only way the discretion came into play was if they were willing to consider post-V-date factors. So it appears that maybe the Court of Appeal, in the short reasons, accepts that you can take into account post-V-date factors. I wasn't at the appeal. I don't know if they did anything any better than that. The other thing on reapportioning ownership interests is Peter and Beblow. And if you read Peter and Beblow, it's an extremely difficult case to follow. But the upshot, I think, is that it's substantially easier to prove unjust enrichment, but I think it's going to be a lot harder for a spouse in a matrimonial property case to get a proprietary remedy imposed via constructive trust to deal with the unjust enrichment. I think that you're going to have a very difficult time running the constructive trust following Peter and Beblow under FLA. Also note that Justice McLachlin did not agree that the reverse constructive trust applied under FLA, and Justice McLachlin writes the majority decision in Peter and Beblow. So now you have even more confusion about redistributing ownership interests, and you have even more confusion about whether post-V-date factors apply. That leaves only the support card. Can you use lump sum support? As I said, Mannarino, Court of Appeal said no. Then you get Moj and Moj is a great case. If you've got no argument, argue Moj. Moj will side for anything you've got. It's one of the truly great cases for that. You can ask Steve Grant, when we argued Elliott and Elliott, both of us relied on Moj. That was our authority on both sides of the ledger. Steve said it made his case. I said it made my case, and we both blasted through in the middle. Justice Meisner, who's known for some useful comments on occasion, pointed out, don't bother arguing Moj at me anymore. It says anything you want it to say. I don't care. So what Steve did was, it was a nice argument. We had Mannarino, then Moj came out. Justice LaRue Dubé says that it's time to review the whole law of support. And what we have to do is deal with our support to make up for the shortcomings of the property awards and to effect an equitable distribution of economic wealth. Not a conscionable distribution of wealth, but an equitable distribution of wealth. Does that now mean we can make greater use out of capital lump sum awards in order to complete the overall distribution of resources, i.e. lump sums to effectively distribute property? Hoare and Hoare, Court of Appeal, March 1993, some 3 months after Moj and Moj, Court of Appeal said no. You cannot use the lump sum to redistribute property. You award lump sums on support principles only. If you look at the factum in Elliott, what you find is the wife arguing, that was then, this is now. Moj changes the rules, and the Court of Appeal in Hoare really didn't even consider how Moj would affect the accounting. You can read Elliott, you can reach whatever conclusions you want off it. I think what the Court of Appeal says is that you award lump sum support on support principles. If you cannot justify the lump sum on support principles, then you cannot get it simply to redistribute the property and effect an equitable distribution of wealth. Proper support principles are, if there's a failure to pay in the past, if there isn't the particular facts, a need for a clean break, and then we get what Elliott was all about, lump sum support to compensate for future economic loss. I don't think the Court of Appeal shuts the door on that argument. I do think what the Court of Appeal says is that in almost all marriages, you're not going to be able to prove it. Justice Morden says you're going to need real proof, not guesstimates and not just throwing the things out on the table. In most marriages, there are any number of economic decisions taken, each one of which has plus-minus implications to the parties, and if you're going to allege an overall economic gain or loss, you've got to prove the overall net gain or loss, and that is all but impossible to do. Certainly the types of reports that were put out in Elliott and in Ormerod aren't going to do it for you. They have been almost consistently rejected by the Court of Appeal in Elliott, rejected by the British Columbia Supreme Court in a case called Petley-Jones and Petley-Jones, rejected in another Ontario case, Dick and Dick. So the straightforward broad statistical report won't work. A lump sum is, I think, still available, but you're going to have to set it up on your support principles, and if you're going to use conferral of a benefit, as in the Keese type of cases, or future economic loss, as in a Steinberg or Ormerod type of cases, you got to call the evidence. And the question is whether, in marriages of significant duration, with all the twisting decisions taken, you can actually prove what your loss is or is not. Bottom line to it, is there a case to be made for unequal distribution of matrimonial property? Not a very good case. It's going to be awfully difficult to do. You have that very, very high threshold. I think you can take into account post-V-date factors following Arndt, Roback, Merklinger, and the rest. I don't think that the support arena provides much real help to you, and that, on time, is my comments on unequal division of property. Pretty close.
Thank you very much, Jay. You've started our morning off well. At this time, I would just like to acknowledge the great help that the staff of the Law Society Continuing Education Department, the help that they've been to this program, and all of them. They really are a great group. Brenda Duncan is the head of the CLE department. she's and we have been assisted in planning this program by the program coordinators, particularly Paul Truster, Laurel Evans, and Kathy Castaldo, and they've done a marvelous job, and I'd just like to acknowledge that at this time. Jay McLeod has paved the way nicely for our next speaker, who will bring us some more enlightenment on this very difficult subject of resulting and constructive trusts. And I point out again that the biographies of this speaker and the other speakers are all in the material, so that we won't repeat that, but please, so that you can convince yourself of the excellence of their qualifications, just glance at that material when you have a moment. So I now take great pleasure in introducing to you Tim Youdan.
Paved the way is an odd expression to describe having to go after Jay McLeod. He, as well as much else, he actually dealt with everything that I planned to deal with. So I think the way to deal with this is just for me to say it all again, but to say it more slowly, so you'll be able to get down now the things you didn't get down while he said it. The paper that I've done and the topic is resulting and constructive trust. I plan today to speak on unjust enrichment and constructive trusts rather than resulting trusts. I think the timing will work out. If I end up finishing after 10 minutes, I'll just have to go back to the beginning again, and it works out just as well that way as well. I'll just tell you what's in the first bit on resulting trusts in a very summary way. Firstly, I summarize what I would call the traditional principles of presumptive resulting trusts. As Jay suggested, it may be that family lawyers need a trust lawyer from time to time to remind them that there were resulting trusts for several hundred years before anybody had ever heard of common intention. And there are resulting trusts based on presumptions about intention that are not concerned with the common intention of the parties. I think a great deal of damage has been done by confusion in the otherwise exciting and path-breaking decisions in Becker and Petkus and Rathwell by confusing statements about resulting trusts. So there's a brief summary of the traditional principles, which, as Jay suggested, you may find useful in the cases that fit within their ambit. Secondly, I critique what I still can only bring myself to call so-called common intention resulting trusts. Not only has that expression, I think, caused confusion in the application of the traditional principles of resulting trust, I think the attempt to create a resulting trust based on common intention has done nothing to lead the law forward. And I find it depressing how one constantly still sees cases where there's a mention made of an argument based on common intention. It's always rejected, but nevertheless, and then the court goes on to deal with unjust enrichment and constructive trust. Thirdly, I summarize a recent English decision called Tinsley against Milligan in the House of Lords, which deals with the interesting and difficult situation where one of the parties to the transaction, or sometimes both of them, have an illegal or fraudulent intention. Basically, they do a transaction trying to make it look like one thing when in fact they intend it to be something else. And the typical example is to avoid claims of creditors, to have tax advantages, and so on. And the question is, in what circumstances can evidence be adduced to show the reality of the transaction? But as I said, I want today not to deal with that stuff, but to deal with unjust enrichment and constructive trust. I'll try not to just read my paper, but also I'll try to tell you from time to time whereabouts I am in the paper. And the material on that starts at page 15. The main point that I'm trying to make is that there's a large gap between appearance and reality. There's a large gap between the court's statements of the relevant principles and the reality of the way in which those principles are applied in actual cases. I think that the recent decision that Jay mentioned in Peter against Beverley is the height or the depth of that, where there's resounding statements of supposedly clear doctrine in the majority judgment of Madam Justice McLachlin, but the application of those principles to the facts of the case, I think, show that the principles have very little guiding or directing force. In reality, courts are left with a great deal of discretion, but a discretion that is not effectively structured because of the divorce between the statement of principle and the way in which the principle is in fact applied. Let me just first, very briefly, set out, and I do this in the paper at 15 to 16, what the position is supposed to be, what the applicable principles that are stated are. The first is that there's supposed to be no special body of principles or rules applicable to family law cases outside of statutory provisions. It's supposed to be the general law that applies the same, or the same rules and principles apply as in other, even commercial cases. Secondly, the well-known principle of unjust enrichment has three elements: an enrichment, a corresponding deprivation, and the absence of a juristic reason for the enrichment. Third, there is no unjust enrichment where one person makes a gift or otherwise confers gratuitously a benefit on another person. The idea is that in that case there is a juristic reason for the enrichment. Fourth, the constructive trust is not the only remedy for unjust enrichment. It's one of several remedies. Fifth, and this is something most recently stated with apparent clarity in Peter against Beverley, the constructive trust has two preconditions, two requirements, not relevant factors in deciding whether it should be given, which is what I would argue the reality is, but supposedly two requirements. The first is that monetary compensation is inadequate, and the second is that there's a link, or sometimes the more elusive word nexus is used, between the services rendered and the property in which the trust is claimed. Finally, that the constructive trust comes into existence not when the court declares it, but when the unjust enrichment from which it is derived occurred. That is supposed to be the structure of relevant principles, and it has an apparent clarity and coherence. I argue that clarity and coherence is apparent but not real, that it is in fact misleading. And I think that the biggest problem and the biggest cause for that divorce between the appearance and the reality is the view that there is no special set of principles and rules applicable to family law cases. The fact is that courts do treat family law cases differently from, say, commercial cases, not just in the way the principles are applied, which is what Madam Justice McLachlin says, but actually in reality in the principles that are used. Now, I try to make that point in my paper by reference to four, and these are illustrations, these are not comprehensive, to 4 points, which I'll just state them now and then I'm going to go on with each one. The first is the way the court treats the third requirement of unjust enrichment, the absence of juristic reason for the enrichment. The second is the range of available remedies. Remember, I said that constructive trust is only one of several restitution remedies, and I want to discuss the principles applicable in determining choice from that range. Thirdly, the supposed requirements for the constructive trust. And remember, I mentioned that it's supposedly based on a monetary compensation being inadequate and a link. And then finally, I want to deal with the effect of the imposition of a constructive trust, when it arises, and so on. And more finally, even than that, if I have time, sort of like the residue of will, if I have time left over, I will make some brief comments on the reverse constructive trust, which Jay also mentioned. So the first of those things, the absence of juristic reason, the third element of unjust enrichment. I want to deal with that by reference to the famous statement by Chief Justice Dixon, which I've quoted. It was in Petkus against Becker that he said it, at pages 21 to 22 of my paper. He says, "As for the third requirement, I hold that where one person in a relationship tantamount to spousal prejudices herself in the reasonable expectation of receiving an interest in property, and the other person in the relationship freely accepts benefits conferred by the first person in circumstances where he knows or ought to have known of the reasonable expectation, it would be unjust to allow the recipient of the benefit to retain it." The difficulty with that is, and this is where we run immediately into the difficulty, I think, of applying the same principles in commercial cases as apply in family cases, is that in a family relationship, people with intimate relationships with each other, and I use the term which actually Chief Justice Dixon used, where they have an integrated relationship, it just doesn't work. People who have, by integrated, I mean, rather than dealing with themselves as individuals with regard to important parts of their lives, including their financial and property aspects of their lives, they think of and deal with each other as a unit, as a couple. In that context, there simply isn't a sharp dichotomy between gift on the one hand and commercial transaction, something supplied in exchange for remuneration or an interest in property on the other hand. People simply do not think, unless they're advised by their lawyers that it's advisable to do so, do not think in such sharp terms. People instead, they make contributions in the expectation that because of that integration of their lives, they will together share in the benefit produced by the joint contributions to the enterprise. And that has been the reality, and that reality has meant that, in fact, courts have not taken serious. Most courts. One of the problems, of course, is with this sort of situation is you don't get an even use of the principles, and occasionally you'll get a strict literal application. But generally, courts haven't taken it seriously. And they've either stretched the facts to find that there was the expectation referred to. Petkus and Becker is a remarkable case itself for a finding that that principle applied on the facts of that case. Sorokin similarly in the Supreme Court of Canada. And Peter against Beblo simply continues that same trend. If you look at the top of page 23 in my paper, actually it just starts at the very bottom of 22. This is the extent of the majority judgment's treatment of this point. Madam Justice McLachlin recited the trial judge's finding that Peter was under no obligation to perform the work and assist in the home without some reasonable expectation of receiving something in return other than the drunken physical abuse which she received at the hands of the respondent. And then the assertion by Madam Justice McLachlin was, this puts an end to the argument that the services in question were performed pursuant to obligation. It also puts an end to the argument that the appellant's services to her partner were a gift from her to him. The central element of a gift at law, intentional giving to another without expectation of remuneration, is simply not present. Well, as I go on to say, there simply wasn't any evidence whatsoever of any expectation, reasonable or otherwise, on the part of Peter. The fact is, as Justice Corey was prepared openly to state, that the courts will presume that a contribution is not made gratuitously unless the contrary is proved. I just realized it may be useful at this point if I just very briefly summarize the facts and the decision in Peter against Beblo. Jay mentioned the case, and I'm going to be referring to it a lot, and not everybody will, perhaps there's somebody here who isn't aware of the facts. It's a case that came from British Columbia. It's a very sad case. You've got one hint of the sadness in the reference there to the physical abuse that the man in the relationship exerted on the woman. I'm just trying to find somewhere where I've summarized the facts here. They are here somewhere. It's also sad because it deals with people who are obviously extremely poor and despite that poverty have taken their dispute to the highest court in the land. The woman was called Catherine Peter and the man William Beblo. They lived together for about 12 years up until 1985, I think it is, in a house that belonged to Beblow, the man, at the beginning of the relationship. It's referred to as the Sycamus property. And it's easier to refer to it as that because it's a house with a bit of a small holding. They both had children of their own. The woman, Peter, had 4, and the man, Beblow, 2. She worked during the relationship as a homemaker, looking after the children, doing the housework, looking after the property. I'm saying that it's relevant, but there was nothing extraordinary. It was just the normal sort of thing that people who perform that sort of role do. And she also did some part-time work and collected some unemployment insurance benefit. The man worked as a grader operator, virtually full-time throughout the relationship, earning presumably a reasonably modest income. And he paid for the majority of the household expenses, naturally, because he was earning most of the money. At the beginning of the relationship, the woman, Peter, had virtually nothing. She had savings of $100. She, at the end of the relationship, had a piece of land that she'd bought for $6,500, and she'd also got a car, and that's about it. So she starts off with $100, and she ends up with some $6,500 worth of land and a car. Beblow, at the beginning of the relationship, had this piece of land, which is worth very little. It was worth about $8,000, and it was mainly subject to a mortgage with, I think, an equity of about $1,000. By the end of the relationship, he'd been able to discharge the mortgage, and he'd also got a vehicle, a van, and somehow, and no mentions made of the value of this, a houseboat. The land, however, was worth quite a lot more than at the beginning of the relationship. I think about $20,000, or maybe a bit less than that. So his wealth had increased, but predominantly because of inflation in the value of the land. The trial judge held that Peter was entitled to the benefit of a constructive trust over the whole of the property, over the Sycamus property, to the entire beneficial interest in it. It's a very, I don't think it's reported, and it seems to be a very short, briefly reasoned judgment. The British Columbia Court of Appeal reversed that, saying that, I won't go through the reasons. Supreme Court of Canada restored the decision of the trial judge and held that Peter was entitled to the benefit of a constructive trust over the property, giving her the entire beneficial interest in that property. There's, as Jay has said, various issues in the case. One, of course, and I think the least controversial, is the view that the woman's contributions in the form of homemaking should be taken into account in the same way that other contributions to a relationship would be. In my view, the much more difficult aspects of the judgment are not the finding of the value conferred by that, and the ones I want to concentrate on are the finding that constructive trust was the appropriate remedy in the circumstances. So, if I can go back to where I was, I've just been referring to that third requirement, reasonable expectation, and the point I've been making is courts don't really apply that generally. They assume that a benefit is not conferred gratuitously, that indeed it's conferred with an expectation of sharing, and that's enough to enable unjust enrichment to apply. The second point I want to deal with is the range of remedies that are available. So we have unjust enrichment. It's the orthodox position that the court now has a range of remedies available to it, and the question is, how does it choose, and what is the effect of the choice? In Peter against Beblow, the majority judgment takes an apparently very restrictive view on the range of available remedies. If you look at page 24 of my paper, Madam Justice McLachlin says, and the quote I have towards the top of the page, 2 remedies are possible, so only 2. An award of money on the basis of the value of the services rendered, i.e. quantum merit, and the one the trial judge awarded, title to the house based on a constructive trust. Now, I think there's a number of problems with that, but the one I want to concentrate on now is the assumption that a monetary award is necessarily measured by reference to the value of the services rendered. Now, one of the problems in Peter against Beblow is that the entitlement of the woman was worked out in an indirect way by reference to the value of her services compared with the cost of a housekeeper. And that fitted into the facts of that case because Beblow had previously had a housekeeper that he paid to do the job of housekeeping, and Peter took her place. And so it was fairly easy to translate the cost that was saved by having Peter in place of the paid housekeeper. But the point I want to make is, firstly, why should a monetary award necessarily be restricted to that measure of damages, or that measure of way of determining the amount of the award? I simply don't see any reason why it should. And secondly, probably more importantly, there's a large number of cases where it hasn't been done that way. Cases in which monetary awards have been made and they haven't been measured according to the value of the services performed, but have been measured in other ways, in particular by reference to proportionality, the proportion of the claimant's contribution compared with the title party's contribution, and then relating those proportions to the value of some particular property or the increase in value during the relationship, and so on. None of those cases were cited in the majority judgment. I've footnoted several of them, and it's not all of them in footnote 52. And I think one of the best examples of this having monetary awards not measured in the way Justice McLachlin says is the Archer and Cornfoot case, which I summarize, and I won't go through now at pages 24 to 25. My comment on this aspect of Peter against Beblow is that it was dicta. It wasn't necessary to the decision. It was stated, as I've said, without reference to any of the relevant cases and without reference to any relevant rationales. So I think it should be treated as dicta and basically not followed. The third point I want to deal with is, assuming that the court is minded in choosing its remedy to award a constructive trust, what are the requirements for the imposition of a constructive trust? Now, in Peter and Beblow, this is a bit of a litany of attack on Peter against Beblow, but it's easy. It's an easy way to do it. In Peter against Beblow, as I've already mentioned, the majority judgment says that there are two requirements for a constructive trust. Page 26, I set out again. I think it's there, isn't it? Yeah, page 26, the top quotation. In order for a constructive trust to be found in a family case as in other cases, this is part of the theme that there's no different set of principles or rules in family cases, monetary compensation must be inadequate, and there must be a link between the services rendered and the property in which the trust is claimed. Becoming quick now, I'm having to move on to Jay's speed of delivery. Two quick comments. Firstly, the idea of monetary compensation being inadequate. This comment isn't in the form of a criticism. I think the interesting point that can be made about that, and I think maybe Jay suggested this as well, is to relate that point to the decision of the Supreme Court of Canada in Rawlock against Rawlock. One of the other problems with Peter against Beblow is that there's no discussion of the relationship between the two cases. Rawlock, of course, says that the constructive trust dates from the time from the unjust enrichment out of which it is derived. However, Peter and Beblow says you only get a constructive trust if monetary compensation is inadequate. And in fact, in Peter against Beblow itself, the court says we can take account of factors such as the difficulty of enforcing a monetary award. And actually the factor relied on for the constructive trust in Peter against Beblow was that the man was so poor and that he had so few realizable assets that the woman would have had a great deal of difficulty in enforcing a monetary award against him. Therefore, the constructive trust was imposed. So that blatantly recognizes that the constructive trust is a discretionary determination based on all the circumstances, not merely the factors that relate to unjust enrichment. And I think that must mean that it's appropriate, or certainly it's arguable it's appropriate, for the court to take into account the award that a spouse in Ontario would get under the Family Law Act as part of the monetary compensation that's otherwise available. So that should be part of the exercise of discretion making in determining whether the constructive trust should be imposed. My second point, and this is really one of my biggest beefs with Peter against Beverley, is this link, so-called requirement. Justice McLachlin says that this link is important as part of a concern for clarity and doctrinal integrity. Well, it seems to me that the effect is actually most unclear, and that the open exercise of discretion that the minority judge, Justice Corey, espoused would have contributed a great deal more to doctrinal integrity. The link requirement, I think, is not an essential requirement at all. There isn't time to develop this now, but let me just quickly mention one or 2 points. First, it's clear from the case that the link need not be established between the particular contributions and the particular property on which the constructive trust is imposed. Madam Justice McLachlin explicitly said, it is sufficient if the subject of the constructive trust is comprised in the assets of the family enterprise. The subject of the constructive trust is comprised in the assets of the family enterprise, and there is a link between those assets, not the particular property on which the trust is imposed, but the assets of the family enterprise and the plaintiff's contribution. Okay. Secondly, at one point in the judgment, Madam Justice McLachlin referred to the requirement of a direct link to the property which is the subject of the trust. Well, again, it is clear on the facts that you do not need whatever a direct link means. You surely, in any normal use of the language, do not, in fact, need one, because the holding in this case was that the contribution by Peter saved Beverley money, which enabled him to pay off his debt and to acquire assets. There was, apart from that saving, no direct connection. Let me just interpose here a question. Is there really any difference, or should there be any difference, between that example and one where the claimant, again, as in Peter and Beverley, stays at home, homemaking, housekeeping, looking after the children and so on, not here looking at it from the perspective of saving money which otherwise the other person would have had to have spent on a housekeeper, but from the perspective of therefore freeing up the time of the other person and enabling, as it usually is, him to go out and be a part of a lucrative profession, earn lots of money, and acquire assets and pay off his debts. Seems to me that there's no substantial reason why there should be any difference between that situation and the one in Peter and Beverley. Well, if that's right, what does link mean? Seems to me it means really virtually nothing, except that it ends up being a relevant factor in the determination whether the constructive trust should be imposed. But what concerns me is that there's this divorce, as I've said, between the statement of principle and the way principle is in fact applied. Coming towards the end, right? Okay, I've got my peroration. You've always got to end on a peroration. Cutting short more of this, the point I want to make at the end is that despite appearances, and I'm really genuinely not being critical of courts here, I think it was an impossible task. Courts have not been able to fashion a system which on the one hand is fair and coherent, and on the other actually has principles that determines the outcome of cases. I think it's crucial, and this is an opportune time because we have the Law Reform Commission coming out right today, apparently, with a report on the topic, that the legislature should deal with this, and it should deal with it in two related ways. One is by extending the scope of Part 1 of the Family Law Act to persons who are not married, but to other persons whose lives are integrated, however that is defined, and obviously it's got to be defined in some way. And secondly, by excluding from the operation of the Act the judge-made doctrines and principles of unjust enrichment and the remedy of constructive trust. Thank you.
Tim, thank you very much, and remind you again that we will learn about the recommendations of the Ontario Law Reform Commission at 3:45 this afternoon. Now, getting on with the rest of the morning program, I'm pleased to call upon Catherine Aitken, who will talk to us about pensions.
Thanks, Jim. You'll see in the materials that I've done quite a comprehensive paper on pensions, and I don't plan to go through that in any detail at all. There's going to be a panel that's on next that's going to talk about some really important areas, one being the difficulties with if and when clauses. That's one of the most problematic areas in pensions these days. They're also going to talk about assumed retirement date, which is a hot issue, and how to question actuaries if you have actuaries giving evidence on cases. So I'm going to avoid those topics completely. What I thought it might be useful to do is just highlight a couple of issues that I think are important in terms of capitalized valuations of pensions. There's three in particular I'll go through. And then I wanted to summarize the legislation that exists that can facilitate the division of a pension, or the treatment of a pension, after you've done your calculations as to what's owing in terms of an equalization payment. Because I think I know a number of you know that area of things quite well, but I do think there's some of you who may not be really clear on which statute applies when, and what you should be really taking into account in working through some of the legislation. And if I have time, which I doubt it, that I will, I'll talk a little bit about double dipping. So firstly, to look at some of the issues around doing capitalized valuations of pensions. One thing that bothers me, and you don't see it discussed very often, is the fact that when actuaries do their valuations, they do the valuation as of the valuation date, quite appropriately, because that's the time we have to focus on. But often by the time the case gets to trial, it could be 2, 3, 4, 5 years later. And still, the value that's being discussed is the valuation date value of the pension. And you have to remember that what that value is what it would cost to buy that, or purchase the deferred annuity that's going to be payable at a later date. And it's assumed that you would have that money available at the valuation date to invest and grow, so that when you start to produce the pension, the deferred annuity down the road, the capital, it has grown, and there's more of it there to purchase that annuity. And that doesn't seem to get taken into account in a number of settlements, and certainly in the court's decisions. In other words, there's no interest that is applied, no prejudgment interest that's often applied to deal with the equalization payment, a good portion of which may relate to the pension. And I think that's an error. I think we really have to be looking at that. It could be a very significant amount of money that we aren't taking into account, and we should be. In the recent decision of Best and Best, which is a decision from Ottawa, Justice Rutherford issued his reasons for judgment on October the 15th. He addressed the point, but quite quickly, and decided he wasn't going to allow any prejudgment interest. And I think that was a shame. I wish he'd done otherwise. The question would be, at what rate would you apply if you're going to look at prejudgment interest? And one thing you should look at what the actuary has assumed that money would be doing, from valuation date to the eventual payment date or the eventual trial. But think about that when you're either settling cases or are presenting evidence at trial, and get your actuary to assist you with that. Ask for the relevant figures. How much did they assume over that period of time that lump sum would have grown? The second issue that I want to discuss is the question of whether the appropriate methodology to use is a termination added value method or a termination prorated method. There is a difference, and it is relevant if there is membership in the plan prior to marriage. It's not going to be relevant if there isn't membership outside of marriage. Does everybody understand, first of all, what the difference is between a termination prorated and a termination added value? How many people don't understand or feel they need an explanation? Okay. Well, let me just offer a brief one. If you're using a termination added value method, what the actuary will do for you is provide a capitalized value of the benefit that the plan member had acquired as of marriage, assuming employment terminated at marriage, and they will provide a second valuation as of separation, assuming the employee terminated at separation. So you have two completely separate values done, and those two values are then plugged in to the calculation of net family property. And that's the added value approach. With the termination prorated approach, the actuary in fact only does one calculation. They figure out the value of the pension benefits that had accrued up to the point of separation. And then they prorate that value based on the number of years of membership in the plan between marriage and separation, that's the numerator, and the denominator is the total number of years of membership in the plan. So they prorate that final value, the capitalized value they've done at separation, based on the number of years attributable to the point between marriage and separation over the total number of years the person has been a member. Now, using those two approaches to situations where there's service before marriage, you can get vastly different results. You will get different results, especially in a situation where at the point of marriage, the pension benefits haven't vested. And that what the person may only be entitled to is a return of contributions at that point if employment terminated. You can also get very different results if there's a lengthy period of service prior to marriage, or in a situation where during the marriage a person's salary has really jumped and they end up having a defined benefit plan that focuses on the best 5 or 6 years of their salary. So you can get very different results doing that. And the question, I frankly had always assumed that it was clear under Ontario law that you had to use the termination added value approach. I felt that was the only approach consistent with the wording in the Family Law Act, which clearly says you have to value assets at 2 points in time. However, there's been a fair amount of controversy about that, and a number of lawyers certainly have tried to put forward the prorated approach, and a number of actuaries feel that the prorated approach is far fairer to both parties than the added value approach. And so if some actuaries were giving evidence in court, they would put forward the prorated approach as the best approach, and some judges accepted that. But again, the case of Best and Best, which is Rutherford's decision from Ottawa, focused on this issue. I can give you it's Ontario Judgment 2444 for 1993. And Rutherford decided that, in fact, it is the termination added value approach that is consistent with the Family Law Act and should be used. And I think that'll be relevant for a number of you in cases, I'm told. I've had a number of phone calls asking me, is that case being decided yet? Okay, thirdly, what I want to focus on in terms of capitalized value of a pension is the fact that the Canadian Institute of Actuaries this summer has come out with recommendations to assist them in doing these pension valuations for us. The document has a very lengthy name. It's the Canadian Institute of Actuaries recommendations for the computation of the capitalized value of pension entitlements on marriage breakdown for purposes of lump sum equalization payments. And they say lawyers are wordy, I tell you. In any event, you can shorten it to the recommendations for marriage breakdown computations. It became effective July 1st, 1993. I think I'll show you what it looks like. So it's an 11-page document. I would suggest that you get a copy of it from your friendly actuary. It's very important to have. It sets out the assumptions that actuaries should be using when doing capitalized values. And it also sets out the ethical considerations that they should keep in mind when doing these valuations, and that's very important. These recommendations replace the recommendations that were brought out in 1988, which in fact never became binding on actuaries, but most of them followed those recommendations. And in many of the actuarial reports that you would have had, or you would see reference to those earlier recommendations. Well, if the separation has taken place or if the report, I should say, is being done after July 1st of this year, the actuaries are supposed to be following these new set of recommendations. Now, the recommendations are supposed to apply if there are no legislative guidelines telling the actuaries how they're supposed to do the valuations. And I think it's fair to say in Ontario we don't have those legislative guidelines, so they will be relying on these recommendations when they do their reports. The purpose of the recommendations, I think, is to standardize reports, to make sure that actuaries are not being used as hired guns for one spouse, and to try to present a value that is fair to both parties. There's a requirement that all reports of the actuaries comply with the provisions in the recommendations, and if they don't, they have to stipulate that they are not, and specifically state how they are not. So you're going to see that in your reports, whether you like it or not. Some of the guidelines given in the report of a general nature are that the actuary shouldn't be looking at benefits that are acquired after the valuation date. Most likely they shouldn't be looking at plan improvements after the valuation date, though the wording is a little vague on that. It says they shouldn't be using a literal assumption of termination of employment on the valuation date. And again, that's a bit vague. I'm not sure if they're talking about the possibility of vesting after the valuation date, or if they're talking about sort of a hybrid situation when you're trying to figure out what the first retirement date may be. If you're allowed to look at projected service beyond the valuation date to figure out when someone may start to collect a pension. That's unclear. You should have a look at that, though, and discuss it with your actuary. If the actuary knows that the valuation may be significantly different if you chose a valuation date a little earlier or a little later than the actual valuation date, the actuary is obliged to point that out. And the actuary is obliged to look at wording in the legislation in the province concerned and the case law to make sure that the valuation technique that they are following is consistent with that legislation or case law. And I would suggest that that means that we should be seeing at this point termination added value reports, not prorated reports. I'd like to see what Mickey Cohen in Ottawa has to say about that, because he just loves the prorated approach. But I know there's some actuaries will have trouble, I think, giving up the prorated approach, but we'll see. In the document, they also deal with some very specific assumptions. For instance, on mortality. One interesting point is that the suggestion is they should take into account the specific health situation of the plan member, except they're not supposed to assume a lower value just because the person is a smoker. Well, I find that rather interesting. I'm not sure that fits with medical statistics, but that's what the direction is to them anyway. On economic assumptions, there's a whole set of guidelines as to what real rate of return should be assumed, depending on what type of plan is being looked at. And these set of assumptions are different than the old set in the earlier recommendations. And that's something that sometimes comes up in the case law. And at trial, people debate whether the assumptions used were appropriate or not in that regard. So you should have a good look at that. The assumptions are different depending on whether it's fully indexed plan, partially indexed, there's ad hoc indexing or no indexing. I mean, it varies completely. I think generally with the assumptions in these new recommendations, the economic assumptions, you're going to see lower valuations. And I've been told by some actuaries that that was in part one of the goals in doing this. Maybe because of pressure from some of the plan sponsors representing their membership. It's an interesting issue. I'd like to know a bit more how that came about. The recommendations also delve into some legal issues, and they talk about how to treat survivors' benefits, death benefits, income tax. And I don't have time to go into the details on that, but you should look at that. One change which is interesting is if the survivor's benefits for a separated or divorced spouse have vested, which may be the case if a pension is in pay, and at the point the pension started in pay, the pension plan member had a spouse, so that spouse became entitled to survivor's benefits. The suggestion is that maybe the value of those survivors' benefits should be valued and included in the spouse's property, which is an interesting point. In regard to assumed retirement date, actuaries are being told to give a minimum of 4 possible dates and give the values for all of those dates. And in the past, some of us would instruct our actuaries which date to use. If it hasn't been agreed by both counsel in advance, the actuary is supposed to give a whole variety of options, and that's going to open up negotiations a little more. I think the significance of the existence of these recommendations is you're going to see a move to people using one actuary instead of each hiring their own. I think it will help all of us understand some of the issues we had better be addressing when we are getting actuarial reports. We better understand those issues and know the significance for our clients. It helps us work through those. I think it's going to reduce the game playing a bit. I think there has been a fair amount of game playing with sometimes experienced counsel taking advantage of inexperienced counsel in terms of instructions that have been given to actuaries to do the reports. It's going to make that much harder, and perhaps will lead to, more equitable results all around. Okay, let me move on to the legislation. There are 3 pieces of legislation you always have to keep in mind. And you have to know which legislation your pension comes under. There's the Pension Benefits Act of Ontario, which deals with all pensions under provincial jurisdiction. And it's in force and has been since '87, the amended version. There's the Pension Benefits Standards Act, which is a federal statute, which covers federal pensions that were not created by specific statutes. It's also in force and has been, I think, since '87. And then we have the Pension Benefits Division Act, the newest act, which is also federal, and it covers pensions that were created by federal statute. That legislation was passed in September of '92, but it hasn't yet been proclaimed in force. And let me start by talking about that one, because that may be the one you know least about, and I'm likely to run out of time. The Pension Benefits Division Act, which is the PBDA, it's included as a Schedule 2 to Bill C-55. It was passed in September of '92. As I say, not yet proclaimed in force, and it won't be until the regulations have been approved under the legislation. They have apparently been drafted by Treasury Board, but they're waiting for new government, new cabinet, new minister to get the things through. The earliest will be January or February of '94. I would suspect it'll be later, if the past is any indication of what the future holds. Under the PBDA, the pensions that are covered are the biggies. It's the public service, it's the RCMP, Canadian Forces, members of Parliament, diplomatic service, Governor General, Lieutenant Governors. The group not covered are the judges, which is very interesting. They're the only ones left out on this. What this legislation allows, which is really helpful, is a division of pension benefits or pension credits at source. That's what's going to be allowed. What's wonderful about that is it gets around the security problems that we are facing with the Ontario situation and that we are currently facing with these federal plans, where if the plan member dies, the pension dies. With this new system under PBDA, the benefits, the credits are divided into 2 separate funds or separate pensions, and they will exist for the lifetime of the person for whom you want to benefit. And that's just critical. The mechanism by which you can trigger the PBDA is an application to the minister by the plan member or the spouse or former spouse. You can make that application after a divorce, a separation, an annulment, and you need a court order or a separation agreement to allow you to make the application. I've gone into some detail in the paper about some specific points dealing with the legislation, and I would encourage you to have a good look at that. Let me summarize just a few. Once the application has been brought, the plan members' pension benefits will be valued by the plan administrator. It's not done by an independent actuary. It'll be done by the plan administrator. How that valuation will be done, we don't know yet because it's all going to be contained in the regulations. So it's very tricky agreeing to this when we don't really know what the valuation will result in until we see the regulations. A lump sum will be determined, and 50% of the lump sum or any lesser amount agreed upon, and it's 50% of the value of the pension that's attributable to the period subject to division. And the period subject to division is something that has to get defined. Once the value has been done and we have 50% of it taken, the options are that it be transferred into a pension plan for the spouse, that it be transferred into an RRSP or some similar savings vehicle, retirement vehicle, which will have to be a locked-in RRSP, or it can get transferred and used to purchase an annuity, present or deferred. One thing to remember is that if right now you are saying, great, this legislation's coming into effect, let's provide in our agreements or court orders that the pension will be divided under the PBDA, please remember that this legislation may never come into force. And you'd better be using an if and when clause now to then be replaced with the division of the pension under the PBDA once it's in force. And you have to be careful in drafting that because there may be some risk that if you get to the point the person retires, you have your if and when clause then coming into effect, that may end up being a reason why the minister will refuse to later use the PBDA to divide the pension. Because one ground of objection that a plan member can raise is that the court order or agreement providing for the division of the pension has been satisfied in whole or in part by another mechanism. So you've got some really tricky drafting to do, a real problem as to how you're going to, handle the reality if we don't get PBDA next year, but it's 3 years from now. You should also be clear when you're drafting a court order or an agreement dealing with the PBDA that you define the period subject to division. If you don't define it, the minister will, and it's going to be the period that the parties cohabited. That can take into account premarital cohabitation. It can also be shorter than the period between marriage and separation if there have been a number of separations over the years. So you make sure you define it in the document that you're preparing. The other thing to think about is that the transfers that are going to take place under PBDA are going to be in before tax dollars. So if you have an actuarial report done and the bottom line is in after tax dollars, which the actuaries normally do now, don't use that figure. You're really going to hurt the non-member spouse. Make sure you use the gross before tax figure as the amount that you may be saying is the limit that could be transferred over to the spouse. Okay? You really watch carefully when the regulations come out. You're going to see that some of the assumptions, like prorated versus added value, like assumed retirement date, some of the economic assumptions, they're likely to be quite different than what our actuaries are actually doing under the Family Law Act. You're going to have to see to what extent you care and that you want to maybe provide for a different value than the plan actuaries are going to be doing. Okay, the Pension Benefits Standards Act, which applies to those other federal pensions I talked about, that act already allows for the division of pension credits or benefits at source. You can either have a separate pension plan set up for the spouse of the plan member if the plan administrator agrees, or you can already get a pension, you can get a lump sum paid out into an RRSP. So that mechanism already exists for some federal statutes. Make sure you're using it. But again, watch the calculations, because the plan administrator will likely come up with a different calculation than your private actuary would come up with. And then finally, the Pension Benefits Act of Ontario does not allow for pension splitting at source. All it allows for is if you have an if and when order or agreement, or if there's a pension already in pay that you say you're going to split, the plan administrator will do that for you and will direct part of it, but it's limited by a certain formula. Part of it will go to the spouse directly, and part will go to the plan member once the pension's in pay. But if the plan member dies, those payments stop. That's critical for you to understand. So you need security or insurance. You need something to make sure that the non-plan member is protected. The only use of this legislation at this point, Pension Benefits Act, is it helps with enforcement from time to time. It helps to divide the income tax liability between the two parties, because the administrator will issue two sets of tax forms. And it can help if there's a termination of employment, because the non-plan member has the same rights as a plan member has if there's a termination prior to retirement. But that's all. Frankly, I think it's an absolute travesty that our governments have done nothing about this issue. And I guess I'd just like to, as a closing remark, say that when we have numbers like this coming out to continuing education programs for the Law Society, and we all realize that likely all of us are going to get sued on if and when clauses at some point in the future, all of us. I mean, there's just no way to do a neat and clean and tight if and when clause. We should be using the opportunity, the Law Society should, to be lobbying the government to say, do something. Obviously for our clients, but frankly also for us, so that our savings, which unfortunately are not in the form of a pension, and which are likely attachable and everything else, aren't going to go to be paying the deductibles that we're all going to have to be paying when we're sued on this. Thanks.
Thank you, Catherine. Well, that cheerful note introduces the panel who will be assembling right now. Now, we're going to have to go through a bit of a shuffle here. There's 3 reserved chairs down on that front table, so that and there'll be a coffee break right after the panel completes its discussion. Then we'll resume for the rest of the morning program. The moderator of our panel today is Mr. Justice Czutrin, who during his days at practice was very interested in this subject matter, so he will he will now ask all the questions that he was attempting to answer at that time, and no doubt will put into practical effect in his judgments after this morning. So with that, I'd like to turn the next presentation over to Mr. Justice Czutrin, who will introduce the panel members.
Good morning. We were quite afraid that after listening to the last speaker, who presented an excellent paper, we would have nothing to say, and you may find that that's probably the case. When this was originally planned, I was still a lawyer, and I was supposed to be sitting over here, and Terry was supposed to be asking us the questions. I'm delighted to say that I will be asking the questions, and I will reserve my judgment for some other time. This is Terry Caskie. This is Jennifer MacKinnon. Their biographies are in the material, so we will go on. We will attempt to ask questions dealing with how to put into play the last paper, as it were, and how do you deal with that in the real world of practice. So with that, let me begin with Terry. Terry, are there any circumstances, or do you believe you can do an if and when?
The if and when clause around my household is known as the God blank if and when situation, because that's the kind of stuff that wakes me up in a cold sweat at 3 o'clock in the morning, worrying about it. Why do we worry about it? We worry about it because we're drawing a trust agreement that basically is out of sync with the existing legislation. The existing legislation does not allow for a division of credits, so we're faced with the problem, having valued the pension, of trying to settle the division or the payment that comes about as a result of calculating the NFP and plugging in the value of the pension. It's easy if there's enough cash to make the payment. It's easy if there are other assets that you can trade and get over it. There are many, many occasions when you'll get to the point where there are no assets and your back's to the wall and you've got no alternative but to look at an if and when, and Jennifer's going to cover the bases that you've got to look at. I think it's important to appreciate the nature of the problem by looking to, Catherine commented on this, there's a document called Building on Reform, Choices for Tomorrow's Pensions, a draft for consultation. It came out in March of 1989. It was a very exciting document because we thought we were going to avoid all of the difficulties of if and when. And the new proposed Section 52 that's in this draft simply provided a member of a pension plan may convey by domestic contract as defined in Part 4 of the Family Law Act to a spouse or former spouse all or part of the member's present and future interest in benefits and rights under the pension plan. It also, in subsection 2 of the draft, provides for a court order to do the same thing. I don't know where this legislation is. It's buried somewhere. There's no prospect of it coming to fruition. The authors of the report comment on the positive aspects of this reform legislation, and it highlights, in my view, the problems that we face in drawing the if and when agreements. And I just wanted to say this. Under this approach, dividing of credits, like under the Pension Benefit Standards Act, a virtually complete separation of the interests of the two spouses would be possible, and the portion of the benefit transferred to the receiving spouse would not be affected by the death or remarriage of the member spouse. Another advantage of this proposal is that an immediate settlement of the spouse's entitlement could be made. In addition, since the spouse's entitlement would not be tied to the member, greater security would be provided for the receiving spouse and greater finality of property division facilitated. The Act does not preclude other methods of satisfying equalization claims, so it is neutral with respect to the decision as to whether the spouses should share pension benefits or transfer their property. As well, a greater degree of harmonization between other legislation governing family property settlements would also be achieved. In my practice, I think like all of us, I try to avoid the if and when. How do you avoid the if and when? I think you look to Section 9(1)(c). You look to trying to structure a settlement over a period of time. Catherine's paper comments on a few cases that give some ideas to us in terms of, in particular, where you have a long exclusive possession order on a matrimonial home. You can perhaps make an order that would provide for the payment when the home is sold. Structure a payment on the basis of a periodic payment over a period of time. You got up to 10 years. I think it makes more sense to be looking to trying to bring some creativity to structuring a settlement by avoiding the if and when.
So do you ever do it?
I have, and I wake up in the middle of the night at 3 o'clock worrying about them.
Jennifer, if you do it, how do you do it?
Well, we've developed a very long, thick precedent in our office that we use both in our settlement agreements and in court, because you have to remember that even though the Court of Appeal has said that the preferred approach is the lump sum, there are still situations where an if and when will be ordered in a trial situation, or where you'll be forced to settle on that basis, particularly where there are inadequate assets to pay a lump sum, or where the age and the proximity to retirement of the parties is such that it's almost inevitable that an if and when judgment would be achieved at trial. And the approach that we follow is, firstly, we value the pension in any event for two reasons at least. One is so that we have our FLA type valuation in the event that future severance legislation comes in. And secondly, as a guideline on the security issue as to how much insurance or other security you should be looking for to protect your client. We then provide that if and when the severance legislation is proclaimed, that the if and when approach to dividing the pension will be transformed and the new legislation will be adopted. And in doing that, we try and reserve to the court the jurisdiction to come back in and deal with any problems that might arise in the future. As Kathy Aitken pointed out, we still don't know under the federal legislation what the valuation approach is going to be, and we won't know it until the regulations are published for public consumption. And so we have a list of checkpoints. For example, it's quite possible that the valuation approach under the division legislation will be different than the approach the actuaries take under the Family Law Act. There might be a deficiency where the claimant spouse would have a higher entitlement under the Family Law Act than, for example, under the federal legislation. So that you need to reserve to a court the right to come back in the future and deal with a potential deficiency. There may be future security problems. If the security that you've put in place lapses for some reason, you should have left open the door so that you can come back into court and ask a judge to make a helping order at that point. And finally, as a catch-all, we have a phrase that says what we've tried to do is to divide the pension equally at a certain point and following a particular method of division. And if that is in any way or for any reason frustrated, the court is left with a general helping discretion to try and set things straight. Now, obviously, the major concern in any if and when is the security. You need to provide a combination of insurance and death benefits to try and protect the claimant spouse's claim in the event that the other spouse, the pension spouse, is the first to die and they've already been divorced, because of course then they will not receive the survivor's pension under the pension plan. It was pointed out yesterday that the most common type of insurance that people have today is term insurance available as a benefit of their employment, and you need to recognize that when they retire, unless there is a conversion option available to them which is exercised, the insurance lapses. So you're really looking for a form of insurance security that will survive retirement. And it may be that you would have to negotiate for or ask a court to order the pension spouse to obtain additional privately owned term life insurance, say to age 100, so that you would have the real security of knowing that there will be post-retirement insurance in place. What we try and do is to work the cost of that insurance into the support package so that even if it's expensive, there's at least a tax savings which could be obtained. The fallbacks are to bind the estate of the pension spouse and to deem that in the event of all else failing, that the non-pension spouse will be deemed to be a dependent under the Succession Law Reform Act, which might broaden the scope of available assets that you might go after if all else fails. Now, there are a number of other clauses that we use. We do set up a trust. We do provide that the pension spouse is a trustee for the other spouse's interest. We have a direction signed from the pensioned spouse to the administrator of their plan, directing the administrator to take all steps on his or her behalf to give effect to the agreement. We provide for what will happen if the pension spouse takes retirement at a later date than expected, so that the non-pension spouse will nonetheless come into receipt of the of support payments in lieu of pension payments at the appropriate age. We deal with the income taxes, who's to be responsible for the taxes on which portion of the pension, and we try and cover off bankruptcy. I'm not sure how successful this would be, but we deem that the pension payment would be deemed to be a support payment in the event of bankruptcy of the pension spouse, with a view that hopefully it would survive the bankruptcy. And I guess the point that becomes obvious from all of these efforts is the extreme difficulty in trying to ensure that you've covered off all the bases and that there will be protection for your client. But as I pointed out at the outset, nonetheless, however unsettling it may be, If you've run out of your list of lawyers that you don't like, or no one in your location will take any more referrals from you of your pension cases, then there are situations where you have no choice but to use an if and when. And this is where you need to get your pencil and paper out and cover off as many events as you can think of.
Isn't that comforting? Jennifer, and we're going to change the topic a little bit. You retain an actuary. In your role as a lawyer, what are the instructions that you give the actuary?
Well, the first thing the actuary needs is the background information, the birth dates, date of marriage, date of employment, date of entry into the pension plan. I think there is still scope to provide some information, if relevant, of any particular health problems that might affect the mortality issue. They'll need a summary of the pension plan and also the pertinent details of the pension holder, for example, the accrued annuity at the date of marriage, if any, and at the date of separation, and the contributions and interests at both of those dates. Another factor which some pensions have is the ability to buy back previous service, and if that has occurred in your case, then you'll have to give particulars of that to the actuary. We try to provide as well a name of a contact person in the employer's office in order to provide some form of verification as to the accuracy of the information conveyed. I had a situation where at trial it materialized that the employee had obtained letters from his employer setting out his accrued annuity and his contributions with interest, had opaqued the numbers out, typed in different numbers, and provided a photocopy to the actuary, and the actuary prepared the report based on the forged document. And luckily we had a witness available at trial who provided the correct information, but it was then apparent that we were left with an actuarial report that was wrong and couldn't be relied on by the trial judge. So it's important to provide a fallback source to check the information that you've received. We would then give instructions, and Kathy covered this in her presentation, as to the approach to be followed in preparing the report, namely whether you want the termination or retirement method, the added value or the prorated, and the various ages at which you would like to have the pension valued. Some actuaries still don't provide income tax calculations unless asked, and so you'd have to cover that off as well as to whether you want them to provide an income tax calculation, which presumably you would, and whether they are to use the marginal rate or the average tax rate.
Thank you. Do you use two actuaries in every case, or do you feel comfortable, Terry, in retaining one actuary?
I feel comfortable in retaining one actuary. I think of what Mr. Justice Walsh said in Marsham, one of the, I guess, the first case that came out in dealing with valuing pensions. You know, the cost of the actuary in the context of the Marsham case in terms of timing, I think Mr. Justice Walsh talked about $2,000 to $2,500. I've seen it go a lot higher than that, and especially if you're in the unfortunate position of having to call actuarial evidence at a trial. So I think it just makes good sense to try to work in a cooperative way with your colleague on the other side and try to agree on one actuary. Mr. Justice Stortini in the Deering case, which Catherine refers to in her paper, I think sets out, in my view, a very attractive step-by-step process in terms of evaluating the pension, retaining one actuary. Mr. Justice Stortini actually made an order that if the parties could not agree on the actuary, then each party would be required to submit the names of two to the judge, and then the judge would choose the actuary. Then the cost of the actuarial report would be factored into the equalization payment. I think it just makes good sense. It requires some judgment in terms of selecting the actuary. However, with the standards that Catherine referred to, it makes that task somewhat more comfortable from a lawyer's point of view because of the ethical factors that are set out in the standards that Catherine referred to. You can get those from any of the actuaries that you work with. I think they're extremely important. So yes, I think you should struggle to have one actuary. The instructions should be reasonable, and let's try to get this issue at least resolved for the sake of our clients. most clients and most lawyers, I think, are finding that the retaining of the one actuary is a good way of doing it. It just seems to work. You can set up a conference call with the actuary and the two lawyers, and any problems, any questions that come up, you can get them resolved and continue to confine the expectations of your client in a reasonable way.
Thank you. Jennifer, when you get the report, what do you look for?
Well, you'll obviously want to check and really cover off the points we've already covered, the accuracy of the report, the approach followed, whether they have taken the added value termination method, whether the tax calculation has been accurately performed. I think really the largest live issue at this stage is the retirement age to be used in doing the present value calculation, and you'll want to be sure that these are all covered. Now, under the new standards, we will be provided with 4 different ages, and if not, an explanation why not will be given. But under pre-September 1st reports, you'll still see, I have a situation in the office now where there's, I think, 3 actuarial reports, and there's only one common age, which is age 65, contained in them. What you want to look for is that you have the information you need on each of the 4 relevant ages, which would be the normal retirement age, usually 65, the earliest age at which the individual could retire with an unreduced pension without reference to years of service after the date of separation, the earliest date at which the individual could retire taking into account years of service after the date of separation, and that really ties into pensions such as a teacher's pension with the rule of 90. And then the ability of if there is another age at which under the pension plan no further years of service can be taken into account in order to enhance the value of the pension. And I think that is really the area now where disputes should be focused in resolving pension issues, namely which of those ages is going to factually, in your case, be the one to be accepted in the valuation process.
But which of those ages do you pick, Terry? And how do you decide that?
Well, in looking at Catherine's paper, I got some comfort in the way I usually struggle on behalf of a client to deal with this issue, and it's the Retzler case, R-E-Z-L-E-R. It's referred to in Catherine's paper, where the evidence in the mind of the judge was not clear as to what the pension spouse was going to do in terms of retirement, and the judge selected a halfway point. I think you've got to look at the evidence in terms of the individual that you're dealing with. As Mr. Justice Czutrin pointed out yesterday, there's probably not a pension spouse alive that would walk into his or her lawyer's office or into a courtroom saying, I'm not going to retire until age 65, because that, of course, will result in a lower value. But I think there are factors as lawyers that we can look to in trying to give our clients the answer to the question as to what's a reasonable position. I think you look at the age of the client, you look at the obligations that the client has in terms of support, dependence, in terms of what impact there has been in making an equalization payment. Health is another factor to look at to try to determine, and activities of the individual. I mean, and what went on in the marriage prior to the separation. I mean, do you have a situation where the individual was expressing the view to his or her spouse that I can't wait to get the hell out of there, and I can't stand going back into class every morning, and I've got this hobby that will generate some income, and I'm out of here at 53 years of age?
By the way, that's generally the evidence I've been hearing, is on one side saying, oh, I never planned to retire. The other one, he wanted to go to Florida right away, you know. So it's the type of thing that, so how do you decide? I know how I may have to decide, but how do you decide?
Well, you know, it's nice if you can take it down the middle. It's sometimes you've got evidence or positions that clients are taking that will cause you to lean more to one side than to the other. I think what's important here is I've never seen a case where the difference between the, say, retirement at age 55, retirement at age 65 is that significant. I don't think there's a case that should be argued in court if you're fighting for less than $100,000 to $150,000. If the difference is $100,000, it sounds like a lot of money, but when you start adding the cost of what it's going to involve in taking that issue to court, having actuarial evidence, et cetera, I don't think it makes a whole lot of difference. And I think it's incumbent upon us as lawyers to try to get our clients to bridge those gaps. And I think there is evidence that you can look at to try to come to that conclusion. I mean, the cases talk about on the balance of probabilities. Mr. Justice Czutrin in conversation mentioned that perhaps it has to be more cogent evidence. And I think as lawyers, we can, in the negotiation process, we can struggle to find those factors that will cause us to come in the middle, which is, Caskie's noted as driving it down the middle every time that he can, or if it's somewhere closer to the one end to the other.
Jennifer, do you agree?
Well, I won't disagree with Terry that we should be guided by the art of compromise and obviously try and settle as many cases as we reasonably can, but certainly in the Dick case, which involved a conservative cabinet minister, the difference in value of his pension, which was a very rich pension, over a 6-year period was about $200,000. The wife's actuaries had valued it on the basis that he could retire immediately, which was true under the terms of the plan, and if he did, the pension would have been worth $200,000, approximately more than the age that his actuary was driving for. And interestingly, in that case, the court accepted evidence from an actuary as to what was the statistical average based on data collected since Confederation as to the average length of time that members of Parliament and cabinet ministers remained in office. And based on that, the presiding judge used a retirement date of approximately October 1995 in calculating the value of the pension. So I think that does indicate, and certainly in my practice, I would regard $200,000 as an amount of money worth litigating. But the other guidance that the case gives us is you could also look to prevalent practices. If you don't have statistical averages, which I think probably we wouldn't have for most professions, you can look at prevalent practices. For example, I think we as lawyers know that many judges will not retire at the first opportunity, but will elect supernumerary status and will remain employed until age 75. So that's a practice which is common in that particular group, whereas in the military, it's a much more, there's a much more rigid requirement that when your time is up, your time is up. And so you can look for that type of a very timely comment. You can look for that type of evidence as well and see whether there is a practice which has developed in your particular client's area that might bolster his version as to when he's going to retire.
You want to comment, I know that.
It's my view that the differences that Jennifer's talking about will only occur east of Peterborough. We folks living in Toronto, number one, will not have to deal with the kind of pensions that Jennifer's dealing with in Ottawa. And we probably won't have to deal with the forgery of pension documents that Jennifer has to deal with in Ottawa.
On that subject, or on that point, last question really, and I'm sorry we had some more to proceed with, but there was a touching on the issue of discount for tax. What is the discount for tax that you feel comfortable with using?
For myself, I use the average tax rate. I think that there's some authority and there's an argument to be said that the marginal rate, the anticipated marginal rate of the individual should be used. But the effect of that would be that the non-pension spouse would be paying tax, in effect, incurred because of substantial income or income generated from assets in which she would not be sharing. And so I think the average tax rate is the one which I personally prefer, and I think that's supported by the case law.
Is there any circumstance where you would use a different tax rate?
I would probably be known to argue for the other tax rate if I was on the other side of the equation.
On the very last issue that will allow Terry to comment on vesting.
In Section 4.1c, property is defined as a vested pension. In my practice, I'm I'm encountering on a regular basis older clients that are separating after having been married once before, and I think I'm hopeful that it's useful for me to cover the basic principles of vesting. Vesting under the legislation that's in existence now will occur 24 months after service. The Pension Benefits Act of Ontario came into effect as of January the 1st, 1988. It is not retroactive legislation. The previous legislation had vesting criteria as follows. It was in effect from 65 to 87, provides that a pension must vest after the employee had 10 years of service and reached 45 years of age. Prior to 1965, there was no legislation or no legislative definition of a vesting, so you had to look to the individual plan. It's particularly important when you have older clients who have worked, say, for a company for 30 years as of the date of separation. If the spouse commenced, say, the employment in 1965, the plan might say that the pension will vest only at the age of 65, so that when you're dealing with the value of that pension, you may have a period of time from 1960 to 1965 that's not vested and therefore would not be subject to evaluation. These are things you've got to look for when you're dealing with your individual clients, assembling the facts, looking to the instructions or putting together the instructions that you're giving to your actuaries. Keep in mind the vesting provisions. Sometimes we're inclined to overlook it and figure, well, it all vests after 24 months. But if you have older clients, you've got to be a little bit more careful.
On that note, thank you very much.
We'll now break for coffee and return to our program in 15 minutes. Thank you.